Our next speaker is Laura Dawes. Laura's expertise lies in the intersections between science, medicine, public policy, and law. She's recently been appointed a research fellow at the Center for the Public Awareness of Science. Although Laura's published on an extraordinary array of topics, today's presentation explores the use of science, medicine, and law by focusing on a precedent-setting case of the use of DNA evidence in criminal law. Laura.
Good morning, everyone. And I begin today by acknowledging the Ngunnawal and Ngambri people, traditional custodians of the land on which we meet today, and I pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander peoples here today. On the 6th of June 1989, Michael Webb, a lab technician at Cellmark Diagnostics, held a transparency like this one up against a whiteboard in the ACT Supreme Court. He was giving evidence in a rape case. The defendant was Desmond Applebee. The lab technician explained to the jury that this was a DNA fingerprint. The lab had used biological samples taken from the rape victim's underwear, her blood, and blood from Applebee. Australian courts had never seen a picture like this before. Webb's boss, Andrew Kaywood, then took over and explained what this strange image meant. That two of the bars represented a pair of DNA characteristics found in the ejaculant taken from the rape victim's underwear, and two of the bars in another channel showed DNA characteristics taken from the suspect, Desmond Applebee. And they matched. Two further tests looking at different loci also found a match between the rapist's DNA and Applebee's DNA. Using population statistics, Kaywood explained that the chance of matches in all three tests was 1 in 165 million people. And so, in the words of the prosecutor, summing up, along came DNA. The introduction of DNA evidence would change how the police, the public, and Australian courts would approach questions of identification in criminal law. So how do we get to the Supreme Court in 1989? 2 years earlier, the UK had been the first country in the world to use DNA evidence in a criminal case in the Pitchfork rape murders. That case has been very well explored in scholarly literature, and it even has an ITV docudrama on it as well, which you can stream. The US also has its own pioneer DNA case, the 1987 case. Florida and Tommy Lee Andrews, also the subject of a lot of scholarly inquiry about how novel scientific evidence is introduced into the law. In contrast, Australia's first encounter with DNA evidence is literally a footnote to history. The Applebee case in the ACT Supreme Court was the first case in Australia to use DNA. My project that I'm talking about to you today is in part aiming to plug this hole in our history by looking at the Applebee case to see how DNA evidence was explained to the court and the circumstances and motivations for trying it. But I'm also going to argue that the legacy of the case is the way in which it illustrates weaknesses in how the Australian system then, as now, engages with novel scientific evidence. It's a work in progress, so I'll indicate as I go along which areas are still under construction and some of the unanswered questions that I still have. And I'd like to particularly thank the Chief Justice Lucy McCallum of the ACT Supreme Court, who vacated the suppression orders and facilitated my access to the trial transcripts. I'm also drawing from media accounts and interviews with people involved or their family members, as well as secondary sources. So, the Applebee case. To say Desmond Applebee was, in that hackneyed phrase, known to police, would be understating his criminal record. Applebee's prior convictions included kidnap, physical and sexual assault, arson and armed robbery. He had served nearly 15 years of jail time. So Applebee was one of a small cohort of very serious, hardcore criminals in the ACT and was known for using weapons, knives and guns. In February and March 1988, there was a series of sexual assaults in Civic and Canberra's southern suburbs, inner south. This included the rape of an 18-year-old girl, the daughter of a diplomat, in this park near Monica. Police suspected a single serial rapist who usually wore a balaclava and used a knife to control his victims. The rapist told one of his victims he had recently got out of jail, which Applebee had, and that he had guns in his car. The police formed a rape task force to investigate, and Applebee appears to have been a suspect from very early on because of the knife use, the mention of the prison sentence and having guns, and he fit the physical description that the victims gave. Applebee was arrested in New South Wales in May of 1988 and found with a balaclava and guns in his car. When questioned about the rape of the diplomat's daughter, Applebee said he couldn't have done it because at the time of the rape, he had been driving from a friend's house and he felt faint and had to pull over and he lost consciousness. When he woke up, he went to Woden Hospital. Doctors there, however, couldn't find signs of an episode like he had described. The police wanted to try the whole series of rapes together, but they had problems with identification. For example, one victim thought her attacker was in his 20s and no tattoos, but Desmond Applebee had heavily tattooed forearms and he was 39. The strongest case was the diplomat's daughter, who had seen the rapist without his balaclava on, but she hadn't chosen Applebee in an identification parade. She had only picked him out later and said that she had been too frightened to do so earlier. So the police turned to DNA evidence to shore up the identification. There's also, according to interviews, an element of wanting to nail the guy with a long prison sentence before he stabbed or shot someone. Now, one of the questions I still hope to answer in this project was whether that diplomatic connection was also a factor in deciding to use DNA. And my suspicion is that it did. Possibly the police felt under pressure and the need to be doing everything that could possibly be done. The court, however, declined to hear all three rapes together, so the diplomat daughter's case went ahead first. Now, at the time, DNA testing was not available in Australia. The choices were two US companies, or in the UK, Cellmark Diagnostics, the Home Office's Forensic Science Lab, or the Metropolitan Police's lab. All were conducting DNA testing using an evolution of the original process invented by Leicester University Professor Alec Jeffreys and used in that world-first pitchfork case. The AFP chose Cellmark Diagnostics to do the testing. Now, why Cellmark? Another question I would like to answer. It may have been the fact that the UK's requirements for expert evidence are more similar to ours than the US. And they also had a longer history of DNA testing and large capacity. Cellmark could do 250 DNA tests a week. The lab technician Webb had personally done over 1,000 tests, and Kaywood had testified in 15 DNA trials in the UK, which made him the most experienced expert DNA witness in the world at that time. So I suspect Cellmark UK was chosen because it had that kind of weight of parallel precedent behind it. The samples were couriered to the AFP's liaison at the High Commission in London and then hand-carried to Cellmark's laboratory in Oxfordshire. Webb and Kaywood were flown to Canberra twice to testify both at the committal hearings and at the trial. So how did the Cellmark witnesses explain the DNA evidence? Now, I'm not going to go into great detail about how this was explained at the trial because you already know in 2023 far more about DNA than the jury in 1989 did. But here's how Michael Webb, the lab technician, explained what he did. He used this diagram as evidence. You get your DNA sample and you cut it up using a chemical called a restriction enzyme, which acts like molecular scissors. And then you grade the DNA pieces by size by putting them into a gel and applying an electric field across the gel. The little bits of the DNA travel more quickly through the gel and end up further along the plate, while the big bits are more sluggish and stay down this bit. So you get a spread of DNA all sorted out by size there. Next, you split the DNA into its two halves and then stick it down onto a nylon membrane, which just kind of glues everything in place. Then you take probes which find characteristic patterns in the DNA and they lock onto them. And these probes have got radioactive particles, highlighters to them, and you put the film next to an X-ray film, or you put the nylon membrane next to an X-ray film, and it burns patterns into the film where the probes have attached to the DNA, and you end up with a picture like that, which is called an autoradiogram. Those bands that you see there, pairs of bands, are DNA characteristics at a particular locus that the probe finds. And there are two bands at each locus because you inherit one from your mother and one from your father. In the Applebee case, Cellmark looked at 3 different loci, so they produced 3 of these autorads. So each one of them looked at a pair of characteristics, making 6 in total. Andrew Kaywood, the Cellmark supervisor, interpreted the autorad saying that it showed the match between Applebee and the rapist's DNA characteristics. And then he used population statistics to calculate the chance of a random match to all 6 characteristics was 1 in 165 million. So, how significant was the DNA evidence in the trial? Now, Applebee's defence had been he wasn't there. He was unconscious in his car at the time of the rape. However, at the start of the trial, Applebee fired his lawyer, who had represented him at the committal hearing, and so he was self-represented. When Applebee himself cross-examined the complainant, the rape victim, he got confused with how to phrase questions in a way that still maintained that he wasn't there. And you say I put the knife down the side of my pants? Yes. And you said you recalled me pulling my shorts back up. The way he framed the questions made it sound like he was agreeing that he was there. So Applebee himself had done initial damage to his case. And by day 2 of the trial, when the DNA evidence was presented, Applebee had got a new barrister, Laurie O'Sullivan. But O'Sullivan had been brought onto the case with less than 24 hours to prepare. Even prosecutors in the Commonwealth Prosecutor's Office said they found it very hard to prepare because DNA testing was so new and there was nobody locally they could talk to. They made sure to have a lot of time with the expert witnesses from the UK beforehand so they could understand it. Laurie O'Sullivan didn't have time, and even if he had, the Aboriginal Legal Service, who had stepped in after Applebee had fired his legal aid lawyer, couldn't afford to bring in the defence's own expert witness. And so the DNA evidence was admitted entirely unchallenged. After the prosecution had set out its case, Applebee gave a statement to the jury. Because of the DNA evidence and, I think, the damage that he himself had done to his case when he had questioned the complainant, Applebee changed his story. He had been there. The sex was consensual. In his closing address, the prosecutor underlined this change of his story. He, Applebee, is pushed into a corner by DNA evidence, and what does he tell you? She consented. The story yesterday, incredible. Absolutely incredible. Note that the DNA evidence had functioned in two ways. One, yes, it was evidence of identification. But two, it also put Applebee's alibi under pressure and caused him to change his story. Many commentators on the effects of DNA in criminal justice have noted these two effects and how the threat of DNA, the moral pressure that it exerts, is a powerful force in prompting confessions or, as in the Applebee case, causing the accused to make strategic errors. The jury took an hour and a half, of which 1 hour was a lunch break, and returned a guilty verdict. A very, very quick decision. The judge sentenced Applebee to 10 years jail. While waiting for sentencing, Applebee, hoping for a lighter sentence, confessed to an armed robbery of a pub in Wollongong, during which his co-robber shot a bystander in the chest. So after the rape trial, Applebee was extradited to New South Wales and tried for armed robbery and attempted murder. He was found guilty and sentenced to 25 years jail time with a 20-year non-parole period. I believe the remaining two ACT rape cases therefore didn't go to trial because they'd been overtaken by the New South Wales attempted murder conviction. So I've painted a picture of a case where the police, under pressure perhaps, dealing with a series of serious crimes, looked to a novel form of scientific evidence to shore up wobbly identification and nail a repeat serious offender. Within the Commonwealth Director of Public Prosecutions, the Des Applebee defence, as it became known, became a long-running in-house joke. I wasn't there. If she was, she consented. If I was, she consented. And besides, it's not my sperm. Now, the punchline to that joke is, however, inaccurate. Applebee didn't, in the end, deny it was his sperm. He and his lawyer accepted the DNA evidence. What are the legacies of the Applebee trial? The trial, although a first for Australia in using DNA evidence, is also one of those stunted branches in history, notable for the pathways not taken, the implications not stepped out. And it's what's not there that to me is especially striking. These absences reflect on fundamental elements of our legal system, principles of matched contest, and how the law engages with scientific evidence. Now, I do think Desmond Applebee was guilty, and I don't think that the sentence was unfair or unjust, but I do think that the trial process had flaws, which meant lost opportunities for progressing how justice and the justice system functions in Australia. There were two live issues the defence could have pursued concerning the DNA evidence, but didn't. One was the civil liberties issue of the police's authority to take a blood sample from Applebee. The police were relying on Section 353A of the Crimes Act, but that section actually referred to taking photographs and fingerprints, didn't refer to taking intimate samples. Later cases attacked that section, leading to an amendment to the Act in 1994 to explicitly authorise taking material from the body of suspected offenders. The Applebee case was a missed moment for civil liberties issues, which is very strange considering Laurie O'Sullivan was the president of the ACT branch of the Civil Liberties Society. The second live issue was the use of population statistics to give the likelihood of the random match. Cellmark used its own database of 200 Caucasian UK residents who actually were mainly employees in DNA pioneer Alec Jeffrey's lab and workers at Cellmark itself. But Desmond Applebee was not a Caucasian UK resident. He was Aboriginal. It was wrong to assume that the frequencies of genetic characteristics in a Caucasian population are the same as in an Aboriginal population. That is, that combination of 6 characteristics that Applebee had might be rare in Caucasians, but might be common in Aboriginals. So it's clear from the questioning in the committal hearing that the defence barrister at that time, Anthony Gillies, had realised that problem, but hadn't shared that insight with Laurie O'Sullivan, and O'Sullivan didn't discover it for himself. We see here that problem of importing science from another country and not adjusting it for Australian circumstances, a problem that September 1988, quashing of the Lindy Chamberlain conviction, should have highlighted. Getting a UK dog expert to come and opine on dingoes was inappropriate. Again, this issue of appropriate choice of population database to evaluate the likelihood of a random match would be left to later cases. By 1990, New South Wales and Victoria were using a US commercial DNA test and US Caucasian population databases. So cases in the 1990s successfully had DNA evidence excluded for using inappropriate population databases. The Applebee case also demonstrates very clearly the considerable disadvantage the defence is at when dealing with novel, complex scientific evidence. Leading that DNA evidence cost the prosecution $30,000. Today, that's the equivalent of $300,000. It's a very rare criminal defendant, the O.J. Simpsons of this world, who can personally fund a serious challenge to novel scientific evidence. Legal aid services did not, and do not, have the resources to do so, and the court and the prosecution were untroubled that the circumstances of the case would not allow the defence to really grapple with the DNA. And I think it's this that's the Applebee's case ongoing legacy. Our legal system then, as now, leaves it to individual cases to interrogate novel scientific evidence. It doesn't offer a systemic process for this. And as I and other commentators on the recent Folbig case have argued, there's a need for an institutionalised assessment process for novel scientific evidence, so the defence isn't entirely unassisted against the scientific resources of the state. There's a wider public interest in those moments of novelty. We shouldn't have cases like Applebee, which are firsts to deal with new types of evidence, but which are also dead ends. Firsts should be opportunities for the legal system to probe and interrogate novel forms of evidence for wider public benefit. The Applebee case should never be a mere passing footnote to history. Thank you.